Now we have listened to 6 speakers who enlightened us on 6 important areas related to environmental protection, which is a very timely topic. And I'm of the view that we did not give them, the speakers, sufficient time to cover the areas they had in mind. So now, therefore, I consider the next item, question item, as the most important item on the agenda, because this will give you an opportunity, you in the audience, to ask questions from the speakers, not only on the areas that they were not able to cover, it is the limited time that we gave them, but also if they were not able to explain sufficiently, now you have time to ask them questions and make your contribution to this conference. Please feel free to ask any question.
Thank you. The last segment I just want to come in. Actually, there were no riot against Muslims in Sri Lanka. You have to correct it. Anti-Muslim riots were not there. Some violence. So, this is the thing. Nationally also, examples of this is given to China. Sri Lanka, you have to be very careful. When you are presenting, selecting words are very, very important, because when you put a slide, this now go to therefore, once again, certain discussions may come. So you have to be very careful when you are selecting words. You have to discuss with the senior, and then these are very sensitive issues. So it was this topic, other than riots. So they were corrected. And the other thing, we have a little bit the police aspect. After the demonstrators arrested, and thereafter they have killed, according to my knowledge, 6 people were killed like that. And a lot of human rights cases are also there. So you have to see the balance. If you are trying to give more powers for police, on the other side, you have not thought about Chapter 3 of Fundamental Rights. So you have to be a little bit balanced. We can go over the case. In the recent Sri Lanka Commission, we conducted inquiry into Paswata, and we have made recommend the responsibility of police when they are dispersing certain demonstrations. We are the opposition at that time. There was a demonstration in our government, a very peaceful demonstration, because the cost of living was very high at that time. This was brutally attacked, and thereafter, in that case, acting Chief Justice Mark Fernandez's judgment is crucially important, because Mark Fernandez's judgment clearly says curtail police power rather than any balance in mind.
Please feel free to ask questions. Please make use of this time. As I said,
it's relating to legal aid. You said that legal aid is limited, that lawyers are available, but not sufficient. We are in a very important seat of higher learning. What suggestions do you make to the system of legal education that lawyers going on to practice do pro bono work? Because in the case where there's a legal aid lawyer, we see a giant on the other side. A president sounds and commands a huge presence in court, and on the other side, a little legal aid lawyer who has passed out the other day. So naturally, judges give more hearing, bailiffs more actively to the president's answer. So in other countries, I understand that successful lawyers spend about 7 months of the year earning good money in a very mercenary way, and 3 months of the year they spend on pro bono cases. So how do you encourage youngsters such as Elisha to take up pro bono cases? And you see the legal learning. What do you suggest to legal educators? What changes need to be made to the legal country?
Thank you very much. First of all, I need to say what you said was actually true, because once I was participating in one of the lectures conducted by Legal Aid Commission, that it is true, people do not take part. They are not showing much enthusiasm to take part in these activities because they are pro bono cases, so they are financially are not supported. But life is not everything about money, which we need to teach our students basically. Interdisciplinary values are there in our system. Especially in the course of LLB, I suggest our interdisciplinary values should be taught to the students. It is the religious perspectives of law, sociological dimension of law. These things should be imparted to the students, so they won't be that money-minded, and basically they are not trying to make their subject, law, just a money-making source. So this should be, the personality should be well balanced. That is what I could say with regard to the academic portion of this particular question. And I think as lawyers, we should be aware of the current issues of this particular society, and we need to try and attempt on showing some, voluntary participation to these issues, and take these matters to the relevant authorities, which should be like, morally we have a duty, but the issue is whether we are expected to do such things mandatorily. So I suggest that our ethical system, the lawyers' ethics should include something like this as well, basically to make it mandatory up to an extent to take part in these pro bono cases. So I hope I gave the answer to the question. Thank you.
May I add a few words to what she said? I remember when I was the principal of our college, we had a very comprehensive practical training program. So one of the items of training was legal aid, for which we gave 15 marks. They had to earn 60 marks to get their certificate of practical training. So that way we encouraged them. And we also got senior lawyers involved on that program. And even the judges were invited. And I must say that it worked well. And some of the lawyers who started working at the Legal Aid Center, I myself was a member of the Legal Aid Commission. So we were able to produce excellent lawyers. Some of them are very senior lawyers now, who serve in the Attorney General's Department as well as on the bench. So we must encourage that kind of thing. As you correctly said, we must do this at the college. We should be part of their training, practical training. Thank you.
This question is to Mr. Ian again. My question is that you discuss the environmental issues in a very extended manner. Do you think that the Sri Lankan Commission has been very active in expanding the horizons of environmental usage. And do we need that separate constitutional rights to be recognized as a reaction to this plethora of cases coming from the Supreme Court?
Yeah, well, I think it's a good question. Thank you, sir. Basically, Sri Lanka jurisdiction and Council Supreme Court decision have seen that special appellate appropriatorship, the case of Hulam case. In that case, Justice Amarasinghe has given a very broad interpretation by using not only the constitutional rights, but he has used some of the international tools as well. So I believe that Sri Lanka Supreme Court actually acting a very active role in promoting the environmental rights with this court interpretation. And also, according to the second question, when you asked me whether we need a separate chapter to the protection of the environmental rights, up to now we have recognized certain rights through what we have. So we have a separate article with regard to protection of the environment. Then it will be very easy for the judges to interpret the cases.
Right, from Ms. Padma, do you think that the existing patent regime would provide for plant variety protection?
So plant variety is an extracted gene, and it's a plant gene extracted from a existing plant and it's improved for another plant. That is the plant variety protection. If it is a novelty is there, it can be patentable under in Sri Lankan legal regime. But the problem is our technology is not sufficient enough to extract genes and extract genes and to have new plants. That's the problem in Sri Lanka, sir. Otherwise, if we have the technology, we can patent in Sri Lankan legal regime. Because it's novelty, the novelty is there. That's why.
In terms of protecting plant varieties through the mechanism of patent, would that be appropriate?
The existing plant cannot be patentable because there is no novelty feature in that plant. But if it is a novel plant, a new plant from extracted gene, developed from the extracted gene, then it can be patentable. The problem is we don't. The pirating occurs because of this lack of technology. That's my main argument. I suggest to implement these things within the country, then we can protect our plants within our country. That's my main argument, sir.
Yeah, true, but under TRIPS application, we might also either provide protection under the existing IP regime or there should be sui generis.
Yes, sir. We try to develop sui generis legal framework, but it's not implemented. But sir, in South Africa, like Philippines, they have sui generis legal framework like protection of plant varieties and traditional knowledge. In India also they have a digital database for the traditional knowledge. But in Sri Lanka, the lack of technology, I think that's the main point. That is the problem in Sri Lanka. But I think if it is developed, if a plant gene extracted by the existing plant and developed for a new plant, it can be patentable because of the novelty.
Do you in your research conclude that patent protection should be extended to plant varieties?
That's what I'm trying to develop.
Okay, thank you.
May I invite Dr. Karnaraj, who is in the audience. He was the former Director General of Intellectual Property.
Thank you, Chair, for the opportunity. It's a big issue. Even the TRIPS negotiators left it open, allowing the member countries to protect plant varieties under patent law or sly justice or otherwise. We are lawyers, we can argue anything, and therefore I don't blame the presenter for arguing that new plant variety can be built. But unfortunately, I just have to share or argue that under the Sri Lankan law, plants to animals are not permitted in Sri Lanka except transgenic microorganisms. That means microorganisms which has been changed with human intervention. That means it must meet the requirements of the patentable invention. Only patentable, otherwise anything not patentable. So in Sri Lanka, life forms are not patentable, either plants or animals. And when you develop the variety, of course you are not developing new plant variety. But by doing this, you are developing a variety, new variety of a plant. Say we have earlier gaha, and earlier colors are now yellow and red, like that black tulip. Somebody wants to make black earlier. Years of changing, not the gene actually, the development of the variety, you can make it black, then you call it variety. When it is a variety, then the question of novelty arises. There is no novelty, there are hundreds of cases of that. That is why even the USA, there are two types of protection. One is plant variety protection, one is patent protection. You can patent if it is new, in your scientific respect, and then industrial application. Lesser than that, you can protect even in the US law as a plant variety. So I would like to share with you the plant varieties are not patentable invention. Only invention can be patented. That is how I should argue. Thank you.
Thank you, Dr. Raman, for enlightening us on that important question.
I would like to extend my appreciation to the presentation delivered by Mr. Prabhakaran. This is one of the areas that I'm closest. So what I want to know is, do you find any relation between the rising ethanol and piracy in the seas and a second part of my question is, do you think we need to revisit the UNCLOS, because there have been a lot of developments since the final version of the UNCLOS, and should we revisit?
I didn't get you properly. Can you just repeat?
No. The first part of the question is there any correlation between the rising sea level and the growth of piracy in the high seas and trade models also? Second part of the question is that, do you think we should revisit the UNCLOS once again, because there have been a lot of developments in both in the maritime zones, regions, and border laws of the sea also?
Okay. I don't think there is any relationship between rising sea level and piracy. Piracy has a different cause. Piracy is going to slowly die down, because that particular need for the pirates to commit piracy
come to an end. It has nothing to do with sea level rise. Second, we don't revisit UNCLOS because that's already done. I have only used it here to draw your attention. We need a regime internationally to define how the existing UNCLOS can be made or made synchronous, I am using that terminology, with the rising sea level. Because when the sea level rises, the baselines will also go backwards. You know, when Sri Lanka gets flooded on the beach, the people who are living there will go to the higher grounds, typical military way of doing it. You seek higher grounds. Similarly, the baselines will also go backwards, inwards, I would say. If that is so, then every country is going to lose a large area of maritime zones. And you must also understand when the sea level rises, even landlocked countries also will be affected, like Laos, see the Mekong River. It can get inundated, or internal waters, which is connected to the sea, can get flooded, people can lose their property. So we need a regime which will somehow bring UNCLOS in tandem with this problem, which is a variable. The UNCLOS is frozen. Any law, the moment it's enacted, is frozen. So you got to create law, legislate law in such a way, looking forward in the future. It is always the police who chases the criminal. You understand that? That is the problem. Criminal may run in a different alley and where the police cannot take the car. So we need UNCLOS to change the sea level rise. That means the nation should not lose. That is one of the requirements. There are many other requirements.
Since there are no other questions, I'd like to sum up these speeches made by the six lecturers. They were very interesting, although they tried their best to do justice to the topics that they undertook. I think they were not given enough time. The 10 minutes is too short, but within the limited time, they